Hello, everybody, and thank you very much for joining us. We're going to talk today about how to litigate a financial remedy case involving a prenuptial agreement. My name is Nick Bennett. I'm a barrister from 29 Beaufort Row, and prenups are at the core of my practice. I spend about half my time drafting them and the other half litigating them on divorce. And with me today is Connie Atkinson from Kingsley, Napley, a partner in the family team there. She does all forms of family law. And Legal 500 2022 described her as the future, the complete package, bright, caring, and way beyond her years, which is all absolutely accurate. What we thought we'd do in our hour together is to imagine that you're sitting there at the beginning of a case looking at a prenup and take you through the different things you need to think about as the litigation unfolds, both if you're trying to make that prenup stand up in the context of a divorce, or if you're doing your best to break it. 3 preliminary points before we start. We're going to assume that the facts and the ratio of Radmacher are familiar to you. Obviously, it's more than a decade old now, and it's informed all our practice. So we didn't think that you would want us to spend your time going through the facts or the ratio in detail. Secondly, we're going to assume that this prenup doesn't make you think there needs to be a challenge to English divorce forum in the first place. We're going to assume it's just a purely English case, although at the end we'll talk about how everything we've said might change if the agreement itself is under a foreign law. And thirdly, of course, we're going to talk about prenups, but everything we say applies with equal force to postnups, there being no meaningful distinction between the two in our law. We've put some slides together. Those slides include some paintings, some famous, some not very famous, which have a connection, albeit in some cases tangential, to the subject matter that we're talking about at the time. They're really intended to be an interesting visual distraction in case the law is too boring for you. Right, with that, over to Connie for the first part of our talk.
Thank you very much, Nick. So I'm going to look first at why prenuptial agreements make a difference and the point of Radmacher. So as we all know, when we're preparing prenuptial agreements with our clients now, we are advising that if done properly, if entered into with appropriate safeguards, the starting point is they're going to be upheld. And so hopefully it's a fairly easy first point to answer, that they are fundamentally important. The court has confirmed that there is nothing unreasonable in mature couples clarifying their financial commitment to one another prior to getting married. And in fact, it goes further than that and says that parties are free to enter into a properly drafted prenuptial agreement rather than risk submitting themselves to the uncertainty of negotiations following a separation or contested final hearing. We know from historic case law, so from Miller and McFarlane and cases that have followed, that when assessing the fairness in a financial remedy case, we have to look at needs, compensation, and sharing. But Radmacher has told us at paragraph 75 that the fact of a prenuptial agreement is capable of altering what is fair. So these are fundamental to us, to our clients. So what does that mean? It means that the court's discretion in a financial remedy case can be fettered. The outcome is likely to be the outcome of the provision of the prenuptial agreement. And obviously there'll be factors surrounding that you want to look into, which we're going to come on to. But in the right case, it's not just going to be of magnetic importance, but the prenuptial agreement is likely to be followed. Over to you again then, Nick.
Thank you. So the first question that arises is, should we do a Crossley? What do we mean by that? Well, Crossley and Crossley was a case from 2007. It involved a husband with £45 million and a wife with £80 million of independent wealth and a short marriage. Mrs. Crossley was on her 4th marriage. That's mentioned at the start of the Court of Appeal's judgment in the case, possibly with some mild disapproval, I don't know. But they signed a prenup, and on their divorce, after this short marriage, the husband issued a notice to show cause why the outcome in ancillary relief shouldn't entirely reflect the prenup that they'd signed, which was to the effect that there would be no claims. Mr. Justice Bennett, at first instance, agreed that the case could proceed in that way, and Mrs. Crossley appealed that decision. The Court of Appeal approved the decision, dismissed her appeal. And so, if you have a prenup in front of you in the context of ancillary relief, should you do the same? Well, the answer is it's going to depend. It obviously has a major advantage, which is that you are, if you're the one wanting the prenup to be upheld, you're requiring the other party to put up or shut up, to explain their case and to come up with the arguments, the compelling arguments that they're going to need post-Radmacher as to why the agreement shouldn't be upheld. But it does contain some risk, because if you pin all your colours to the mast of that agreement and you don't succeed, then of course costs will follow. And you have spent, in the time it takes for any such application to get before the court nowadays, you spent probably 6 or 9 months on a discrete application, which is then going to delay the substantive ancillary relief if you lose. So I think the answer to the question, Crossley, is highly fact specific, and you're probably best advised only to do it if you want the agreement to be upheld, if you have a very high degree of confidence that that agreement is going to work. As I say, the facts of Crossley were very unusual. A short marriage between 2 people of very significant independent pre-acquired wealth. In that context, it's not surprising that that Mr. Justice Bennett and the Court of Appeal agreed that the prenup was of such magnetic importance, such staggering importance, that it would be dispositive of the case. There aren't going to be very many cases which fall into that camp. Most cases will involve a degree of risk and a degree of ambiguity as to the status of the prenup, for the reasons that we'll soon see, that mean you can't have complete confidence that a Crossley type application will succeed. It's also important in this context, I think, to understand what Crossley does and what it doesn't do. It does short circuit the process, the standard process of ancillary relief, but it doesn't eliminate it completely. It's not a means by which a party can avoid financial disclosure at all. In Crossley, Mr. Justice Bennett said that Form E's should be completed, but without narrative sections, except in relation to the prenup. No documents exhibited, no need for answers to questionnaire before the hearing of Mr. Crossley's application, his notice to show cause. So even in a case where the prenup was obviously going to be of such magnetic importance as it was in Crossley, a Form E still had to be done, disclosure had to be given, and it was acknowledged that the court, having to go through the Section 25 factors and analyse whether a proposed outcome was fair, couldn't rely on the prenup alone, but had to have a proper understanding of the parties' financial positions as they were at the time. So don't think, if you're considering a Crossley application, that it is a means of avoiding everything. It slims down the process, but it doesn't dispose of the need for financial disclosure. Let's move on to thinking then about what arguments you're going to use if you want to hold up the prenup or if you want to break it. And we can think about this across a range of different points. We've got factors concerning the way in which an agreement came to be negotiated, procedural factors. And then we've got factors concerning the financial outcome of the prenup in terms of sharing and needs. Let's start with procedural factors. The first thing you want to think about is when the agreement was signed. Because of course, Radmacher, revolutionising the law as it did over a decade ago, means that there may well be an opportunity for you to argue that an agreement signed before that judgment should not be regarded in the same way as an agreement signed afterwards. And the Supreme Court explicitly envisaged this at paragraph 70 of the judgment, because they say in the past it might not have been right to infer from the fact of an agreement that the parties intended it to take effect, for they may have been advised that such agreements were void under English law and likely to carry little or no weight. That will no longer be the case. Thus, in the future, it will be natural to infer that parties who enter into an antinuptial agreement to which English law is likely to be applied intend that effect should be given to it. So have a think about the state of the law at the time the agreement was executed. And if we're talking about an agreement in the 1990s or 2000s, at a time when the advice that the parties will have received will have been to the effect that they could not be sure that this document would be binding on divorce. Indeed, they will probably have been advised that prenups were of not significant weight, then that can influence the status of the agreement as it is now. Remember, you're looking to try and demonstrate that the parties knew that the agreement they were signing would be effective on divorce, if you want to hold it to hold up, or otherwise. So have a think about the timing and see if you can craft an argument to the effect that if it was pre-Radmacher, it should be given less weight than if it was post-Radmacher. Then you've got to think about financial disclosure. There's a broad point on this. It's what's happened, I think, in the 10 years plus since the Supreme Court judgment is that all of us in practice drafting these documents have looked for simple boxes to tick. So we can say to our clients, well, look, if you've had financial disclosure, if you had independent legal advice, and if you signed 28 days before the marriage, then you're going to be fine. If you don't tick those boxes, you're not. But that is not the right way to look at the Radmacher framework, because the Supreme Court explicitly say that there is no need for box ticking, and that each, in the context of a system where prenups aren't formally binding, where judicial discretion is retained, and each case is fact specific, and the weight to be given to the agreement from divorce to divorce will depend. So although it's right to say that financial disclosure is normally there and would be expected, if you're seeking to uphold an agreement where very limited disclosure has been given, it's not necessarily fatal. What they say in Radmacher is not that there must be disclosure, but that each party should have all the information that is material to his or her decision. And they explicitly refer to circumstances where a party is indifferent to detailed particulars of the other party's assets, just like Mr. Granatino, of course, because he didn't have financial disclosure in his agreement, and nevertheless it was enforced against him. So you need to see the presence or absence of financial disclosure through the prism of materiality. Did it matter in that particular negotiation for that particular couple that a detailed particulars of disclosure were given, or did it not matter? And of course, perversely, the higher the greater the wealth, the less detailed disclosure needs to be. Somebody marrying a billionaire needs to know not much more than he or she's a billionaire. So don't think that the absence of financial disclosure is necessarily fatal. It might not be. It will depend on facts. Independent legal advice comes, I think, into the same category because it's described by the Supreme Court in the same paragraph, 69, as obviously desirable, but of course that's different to its being essential. You want independent legal advice as a way of demonstrating that the parties obviously understood the detailed terms and understood how the agreement fits into the framework of a financial remedy case. But you, again, have to see the presence or absence of independent legal advice through the prism of materiality. Did the party signing have an understanding of the intention of the agreement, and did he or she understand that it would have legal effect? Was the opportunity to have legal advice and declined? The particular dynamics of the negotiation and whether or not the party who's seeking to resile from the agreement is sophisticated or not will all bear on this question. Again, remember, Mr. Granatino didn't have independent legal advice. All he had was an explanation by the notary in Germany of the terms of the agreement that they were about to sign. He was offered, given an opportunity to have legal advice, he didn't take it. So again, although superficially one might think that the absence of independent legal advice is always completely fatal, it might be very damaging to a prenup, but it's not necessarily completely fatal. And there are circumstances where you might be able to argue that its absence doesn't pose a problem. Now back to Connie.
Thank you. So I'm just going to touch on vitiating factors and also the comments about concepts of undue pressure and unworthy conduct. So if there are vitiating factors which come from contract law of duress, fraud, misrepresentation, then that's likely to be fatal to the prenuptial agreement and the weight it's going to hold. But those concepts do come from contract law and can be quite difficult to prove. And so we have seen across our case law that the court goes further than that, looks at other factors such as undue pressure and unworthy conduct. So looking back to the case of Edgar, which is obviously now quite old, the court said that when assessing the weight to be given to a prenuptial agreement, regard must be had to the conduct of both parties leading up to the agreement and subsequent to it, and to look at all of the circumstances that may affect each of these two human beings in what the court said was a complex relationship of marriage. So undue pressure by one side, we are told, exploitation of a dominant position to secure an unreasonable advantage, we are told, is going to be relevant when looking at the weight to be given to a prenuptial agreement. And as we know, Radmacher then also looked at that at paragraph 71. The Supreme Court said the first question will be whether there is any of the standard vitiating factors, so duress, fraud, misrepresentation. And if there are, those factors will negate any effect that the agreement might otherwise have. But unconscionable conduct, such as undue pressure, which isn't as strong as duress, could also eliminate the weight to be attached to the agreement. And other unworthy conduct, such as exploitation, again, same wording, of a dominant position to secure an unfair advantage, could reduce or eliminate the weight to be given to the document. And Radmacher at paragraph 72 gives some more guidance about that and touches on the different circumstances of the case. So the court can take into account a party's emotional state and what pressures he or she was under to agree to the prenuptial agreement. But again, this can't be considered in isolation from what would have happened had they not been under those pressures. So what would they likely to have agreed? And so we're told that matters such as age and maturity are likely to be relevant. So have a couple been in a relationship before? Is this a second, third, fourth marriage? Was there a prenuptial agreement? What was the outcome of those divorces? Because if they have been in previous long-term relationships, married or not, then it may be that they had a little bit more thought about what might happen in the event of a separation of this relationship and therefore this prenuptial agreement. And there's a distinction, therefore, between couples who may be young, have just got together and have not had to think about those kind of aspects. So as I said, the age and maturity and the history of the relationship is going to be relevant when looking at the impact this might have on the weight to be given to the prenuptial agreement. And just thinking about it from the drafting perspectives as well, we're obviously used to, as lawyers, taking attendance notes when we're in meetings with our clients, but actually it's probably particularly important in these cases if you have somebody who is saying they feel under a particular amount of pressure or they're particularly tearful or there are other elements that you actually want to make sure you've recorded in your attendance note in case they are relevant later in the event of a separation and there being any litigation arising out of it. I just wanted to touch on the 21 or 28-day time limit that the Law Commission had recommended in terms of having the prenuptial agreement signed before any wedding. I think the general view is that it's not fatal if you haven't signed it 21 or 28 days before the wedding, particularly if there has been a discussion about the need for a prenuptial agreement long beforehand and also drafts floating back and forth between the parties. I'm just going to touch on also the emotional context, which we can see from the authorities, which are on the slides, which are also playing a part in discussions now in respect of the impact and the pressure that parties are feeling under when entering into a prenuptial agreement. So in the recent case of Traherne and Lim, the court was asked to look at the modern approach to domestic abuse, consider that impact that might have had on the parties, and therefore did they enter into the prenuptial agreement freely. At paragraph 27 of the Traherne judgment, the judge says that the comments in Edgar stand the test of time in his view. And he went on to say that controlling and coercive behaviour would plainly be an example of undue pressure, exploitation of a dominant position, or of relevant conduct. It's a part of all of the circumstances as they affect the two parties in, same wording, the complex relationship of marriage. So this isn't two people entering into a commercial transaction. The court is able to look at what these two people looked at, what they felt and the experience they had when they were being asked to enter into the prenuptial agreement. And the same with the case of WC and HC. In that case, the judge found that although the wife was under pressure to sign by her husband, the court didn't find that it was undue pressure, let alone duress, and actually found that both parties were under pressure from different sources and in different ways. And so the judge rejected in that case that it was a long-standing pattern of controlling behaviour by the husband. So although in those two cases that particular behaviour wasn't found to have the impact on the outcome of the financial remedy, we are being told that certain circumstances might be. So it is important to understand those and know that you have the detailed history from your clients when you're taking instructions. We know that in our agreements often there's a recital that either or both parties wouldn't marry without the prenuptial agreement, and I think that clause can be said to cut both ways. I mean, is there a pressure to sign because if you don't sign, you don't get married? Well, that's pressure on the financially weaker party. But if the financially stronger party is saying, well, I won't get married without it, then I think the comparison isn't necessarily, let's compare what the financially weaker party would get if there wasn't a prenuptial agreement. Actually, the comparison might be what would the financially weaker party get if they hadn't been married, because that's the position of the financially stronger party when saying that if there isn't an agreement, then the marriage won't take place. And I just wanted to touch on the Radmacher guidance that we've all heard, read and understood, that the parties are likely to be held to an agreement as long as there's a full appreciation of its implications and an intention to be bound by it. And as Nick has touched on, the absence of legal advice or even disclosure doesn't in itself mean that the prenuptial agreement isn't going to be upheld. But again, I think in the context of the pressure point, if the agreement is signed just before the wedding, and I think this happened in the 2020 case of AD and BD, where the wife, I think, was given the agreement a day or two before the wedding. She didn't have chance to consider its contents. She was unfamiliar with the concept and therefore couldn't have really understood the impact of that agreement, or therefore have an intention to be bound by it. So again, it's just important to take the background detail so that you can understand that in respect of the arguments that you may want to run. Over to you again, Nick.
Right, so we've talked about the procedural points that might give the agreement in your case extra weight or might allow you to unpick it. Let's think about the financial provision the agreement makes and what arguments flow from that. I said earlier that following Radmacher, the profession has wanted to find simple tick boxes to be able to explain to our lay clients that agreement A will be valid because it ticks those boxes, agreement B won't be because it doesn't. One of those tick boxes, I think, is, well, we can exclude sharing claims because the Supreme Court in Radmacher said that it would be reasonable to allow a husband or wife to retain property that came from his or her family, or that he or she had brought into the marriage. And so that's become hardened, if you like, into a general feeling that excluding sharing claims is fine, excluding needs claims isn't. But again, I think the Radmacher judgment is more complicated than that. I think we need to be more careful. The Supreme Court do indeed say that the exclusion of sharing claims over non-matrimonial property should be acceptable, and they say that it's perfectly reasonable for spouses and their wider families to want to do that. But they're much more cautious about the idea that you can use a prenup to exclude sharing claims against property which would otherwise be matrimonial. They quote Lord Justice Ricks in the Court of Appeal asking this question: if a prenuptial agreement should provide for no recovery by each spouse from the other in the event of divorce, and the marriage should see the formation of a fortune which each spouse had played an equal role in their different ways in creating, but the fortune was in the hands for the most part of one spouse rather than the other, would it be right to give the same weight to their early agreement as in another, perhaps very different example? And the Supreme Court say that the answer is likely to be no. They make that more explicit at paragraph 81. If the devotion of one partner to looking after the family and the home has left the other free to accumulate wealth, it is likely to be unfair to hold the parties to an agreement that entitles the latter to retain all that he or she has earned. So if you have a situation where a young couple are marrying with limited assets, let's say, to take a crude example, the husband is about to start work in the city or in private equity. The wife has few qualifications and she very quickly becomes, they have a traditional marriage, she very quickly becomes a housewife and mother. They sign a prenup under which she agrees not to make any claim on his assets except to meet limited need. And he amasses a colossal fortune during the course of a 20-year marriage. It is more complicated than merely saying, well, okay, she has no claim to share in that wealth. It's all about need because of this paragraph in Radmacher. The Court of Appeal in Brack emphasised that point. They say, even where there's an effective prenup, the court remained under an obligation to take into account all the Section 25 factors. Such an approach may, albeit unusually, lead the court in its search for a fair outcome to make an order which, contrary to the terms of the agreement, provided the settlement for the wife in excess of her needs. And so if you're acting for the wife in my hypothetical example, and if she has her needs broadly met, but is still, but that is, the effect of that is that she receives a very small proportion of property, all of which was generated, but most of which was generated during the marriage, then you've got some arguments. And you may well want to, if you have the resources to do it, and if you have some courage, you may well want to take this point to litigation, because it's pretty clear from Radmacher and supported by the Court of Appeal in Brack that a prenup which does that might well not work. It's said to be a point of application only in unusual cases. And it may well be that the judge requires a little bit of persuasion and understanding to get to the point. But I think this particular aspect of Radmacher has been largely overlooked and is ripe for some litigation. So, where a prenup, to summarise that point, where a prenup seeks to exclude sharing claims against a significant amount of matrimonial, what would otherwise be matrimonial property, there may be opportunities to avoid the full effect of its terms. Back to Connie.
Thank you. So I'm going to look at agreements and whether they meet need. So what does predicament of real need mean, and the different approaches that we've started to see? As we know, if needs are adequately met, then an agreement can prohibit further sharing, and obviously subject to Nick's comments just then, sharing of non-matrimonial or matrimonial assets. So we're told that the autonomy of adults should be respected, and that there's nothing inherently unfair about an agreement that seeks to ring-fence non-matrimonial property. But that's not overly surprising because if there wasn't a prenuptial agreement, obviously we know that there is often arguments to be had and a slightly different treatment in respect of assets that are brought into the marriage or that are received by way of inheritance into them during the marriage. But the longer a marriage endures, the more difficult it's going to be, because the greater the chance that it might not be fair to uphold the parties to an agreement because of unforeseen changes in circumstances, not just children, but health issues and where they might live. Are they going to live abroad? The standard of the property they're in, does that change significantly? So as time passes, it can be much more difficult to predict what's going to happen, and therefore understand whether it's appropriate, fair, and the circumstances always going to meet each party's needs in the event of marriage breakdown. And in Radmacher, we're all familiar with the wording, but the court said that the parties in that case were unlikely to have intended that their prenuptial agreement should result in one party being left in a predicament of real need while the other enjoys sufficiency or more. And so in cases where there's going to be a big disparity, for example, in financial positions, or particularly in the homes that children will go between, then it may be that the court finds it's unlikely to be fair to hold the parties to their agreement. But we've heard a lot, particularly when quoting Radmacher, about this predicament of real need. But cases such as the McConnell case that was Mostyn-Jay's in 2019, well, he actually said this agreement doesn't meet the husband's needs, but he doesn't take the language used by the Supreme Court in Radmacher of predicament of real need, or suggest that needs in a prenuptial agreement case should be looked at in any lesser way than needs assessed in a normal financial remedy case. And he says, if you have reasonable needs which you cannot meet from your own resources, then you are in a predicament. Those are real needs. And so it is actually a really difficult question to answer, because there's slightly different judicial treatment, but also it will depend on the circumstances of the case, as ever. I do think it's worth noting that in cases where the financially stronger party the financially weaker party has a good earning capacity, then I think the predicament of real need is going to be slightly less of an issue, because they have their own mortgage capacity, and then looking at the disparity in their financial positions and homes isn't going to be as stark than if the financially weaker party is a mother who has stopped work, is out of the marketplace, and has looked after children. Then their position is obviously going to be much more different. And we have talked, I think, in the industry and within the team about those cases where you try to meet needs, but perhaps on a Schedule 1 basis. So you're topping up to provide funding for a period of time, and how there are arguments, I think, about post the reversion of the extra capital being provided, because is it fair to leave that party in perhaps a predicament of real need, or with their needs not being met after their children are 18, 21, or whatever the period of time that's been agreed. And there isn't a straightforward answer. It is, as ever, fact specific, and we can already see that judges are treating them in slightly different ways. There's also then finally the unresolved question as to whether the whole agreement, prenuptial agreement, is thrown out if one party's needs aren't met. And I think that the answer is probably no. In the results that we've seen, what the court will try to do is tinker with it, maybe consider what parties haven't thought about that might help to meet a party's needs. We've seen in judgments round up to take account of contingency funds or stamp duty, etc. But overall, the starting point is likely to be that the prenuptial agreement will be upheld, albeit we'll tinker with it to deal with any unfairness or needs point, rather than tear the whole thing up.
Right. Well, finally then, let's think about the situation that confronts you when, sitting in your office at the start of a case, you're looking at a prenup that isn't made under English law, but it's made under a foreign law. What impact does that have, if any? Well, the first thing to say is that it may be that the document you're looking at will be treated in a different light to a purely English prenuptial agreement, if you can establish that the parties, when signing it, didn't intend it, or didn't understand, rather, that it would have the effect of completely governing their financial rights on divorce. Because particularly in the context of civil law marriage contracts, they tend to be made with different factors in mind. If you're in continental Europe, you are obliged to make a choice as to the property regime you want to have with your spouse. Or if you don't, then the law of your country will supply one by default. And these documents are usually seen in the context of succession on death, the rights of third-party creditors against the assets of the marriage as a whole, as opposed to the assets of the husband or the wife, and so on. And of course, they're done often with significantly less formality and negotiation than we're used to in our law. And so sometimes litigants have been able to say that although the marriage contract that they have signed would in fact have been binding in the context of a divorce in their home country, they didn't appreciate that, so they can't be said to have signed it with a full appreciation of its implications, and therefore under the Radmacher test it shouldn't be upheld against them. That, of course, like many things we've said, is going to be fact-specific, and there's going to need to be detailed evidence from the party in question about their precise state of knowledge. But so that's the first thing to say. You might be able, if you dig deep into the circumstances under which the agreement came to be signed, to successfully assert that your client didn't understand its implications. It's clear that only English law will be applied to a financial remedy claim, regardless of what a foreign law marriage contract might say. Otherwise, the parties may ask that their financial relationships be governed by the law of France, Germany, Spain, or wherever. The English court won't accept that. It will only apply English law. But that doesn't, of course, mean that the principles of foreign law are irrelevant. And to the extent that the parties may have chosen a property regime which has the effect that no claims can be made against a wide sweep of property, both matrimonial and non-matrimonial, that is important evidence of their intentions, which can be brought into play in the litigation, whether or not the agreement itself is found to be valid. The next thing to say is that is the other side of the argument that I've just made about the binding nature of these documents. Because if you can show, or if the party seeking to resile from the agreement can't show that they didn't understand its legal effect, then you've probably got a better chance of the English court finding that the agreement should be upheld, because it comes from a law and a system of jurisprudence and a culture where these agreements are absolutely binding and where the discretion that the English court has simply doesn't apply. So unless you've got somebody who's able to say, well, look, I didn't understand what I was signing, you can then make the argument, well, if there had been a divorce in France, Germany, Spain, or wherever, the equivalent judge would not have had the opportunity to tinker with the terms of this document. He or she would have been obliged to enforce it in full. The final point to be made about these agreements is that very frequently, as I said, they will have been negotiated and signed with much less formality than we're used to. An absence of independent legal advice is pretty common. Back to Granatino and Radmacher, who simply saw a notary in Germany. Not uncommon at all for these documents in continental Europe to be discussed between the parties, potentially one party to have some advice, but ultimately for the notary to be the person not advising the parties, but explaining to them the terms of the document they're about to sign. Disclosure is unusual in the context of a civil law agreement, and the question of timing very rarely applies. These agreements are very often signed in the lead up to a wedding with a limited amount of negotiation. So superficially, one might think that it is easier in those circumstances to persuade the English court to throw out the agreement. But the position's more nuanced than that following the Court of Appeal's judgment in Versteeg. That was a case involving a Swedish couple who, while living in Sweden, signed a very simple, short agreement under Swedish law, I think no more than a page or two. On their divorce many years later in England, Mrs. Versteeg argued that the absence of independent legal advice and financial disclosure meant that that agreement should not be upheld against her for those reasons alone. And the Court of Appeal wasn't persuaded by that argument. It held that for international couples shouldn't have to expect to constantly renew arrangements originally embodied in a prenuptial agreement as they moved around the globe, and shouldn't think that because the English system was comprehensively different to the Swedish system, that had the effect that English procedural standards and requirements had to be imported in to the consideration of the agreement at the end of a marriage. Now, it would be easy to say that meant that you can be confident that any foreign agreement that meets its own procedural standards will satisfy the English court. But I think we have to be a little bit careful on that. Mrs. Versteeg was a pretty terrible witness. And there was evidence before the court at the first instance that she knew precisely what she was signing, and so Savita Singer was able to find that she had signed the Swedish document with a full appreciation of its implications, regardless of what we might think of as procedural flaws. Secondly, the effect of the agreement and the parties' financial circumstances were such that she would remain a very, very wealthy woman, even if the agreement were enforced in full, rather similar to Mrs. Crossley. So it appears that she didn't have open to her an attack on the agreement by reference to her need, clearing the way for the Court of Appeal to say that her attack on it on procedural grounds shouldn't succeed. An unusual set of facts, both in terms of the evidence that she gave and the financial consequences of the prenup. And I don't think we can be completely secure that a foreign agreement procedurally defective by English standards is always going to be nodded through, as it were, as ever, to repeat a phrase that Connie and I have both used repeatedly today. It's fact specific. There we are. I hope we've given you some food for thought. And the next time you're sitting in your office pondering the weight that a court's going to be giving to a prenup in the context of a financial remedy case, that you can use some of the things we've talked about today to help you on your way. Thank you very much.